And on today's show, why the biggest villain in estate planning is not the IRS, but procrastination. Part 1 of this week's series on estate planning update for 2015 with author and top producer Mike Kilborn, CLU CHFC. Hi everyone, I'm Steve Savant, syndicated financial columnist and contributing author to InsMark, Life Specs, and Backroom Technician. Let's get down to business. Welcome to the show, Mike.
Yeah, thank you.
Mike, I'm ready for the update because, you know, there's a rumor out there that basically estate planning is dead and your entire practice proves otherwise.
Oh my God, estate planning is so important, and it doesn't have to be all about how much the Uncle Sam gets, which used to be the biggest part of the formula, but it's how you leave things and in what form and how to create incentive. I mean, I can think of a case where we had a client who had a child who was a deadhead. So, you know, the deadheads, Tony Garcia's dead. Is it Tony? It's Jerry Garcia.
Jerry Garcia, yeah.
He's dead, but
dead,
the son would go from concert to concert selling tie-dye T-shirts, and his parents were fabulously wealthy, but they were worried about, you know, him being a spendthrift. So what we suggested was that they contribute $2 to him for every dollar he earned legitimately. And they said, "You can do that?" I said, "Yeah, you can do anything that's not illegal or against public policy." So we actually designed a trust that created incentives for him to do better.
So you're really dictating from the grave.
Well, in a sense, I guess you could say we were there. But you know, really, estate planning should be living planning. There's a lot of things you can do while you're alive that will enhance your life, your family's life, and then in your death, things will help enhance the lives of those you leave behind.
Well, now the traditional issue, and a lot of our advisors would be sitting there saying, well, I thought, you know, I shouldn't even be thinking about estate planning until I get above the unified credit. But you do a lot of things that are also well below that.
Oh, absolutely. Later in some future show, we'll talk about a wonderful tool that actually improves your lifestyle, helps your children, and takes care of charity, all in the same formula.
Now, Mike, you said, and I thought it was going to be the IRS. I thought Uncle Sam was our enemy. But you say the number one enemy to estate planning is people putting it off.
That's right. The biggest villain, as you said, in estate planning is not the IRS, it's procrastination.
So let's say if you go to a client, how long I mean, you told me some staggering stat about people delaying and procrastinating on this whole issue.
Well, actually, between the time that people have the gap between people's visiting their estate plan is approximately 19 and a half years. Well, that
how many times has the law changed?
Well, sometimes yearly. But the bottom line is that some plans are old, they're full of holes, and we look at them and we find where they need to make moves. And so my first recommendation to those that are listening today is that they recommend to their clients that they have a revocable living trust, which is the basis to a good plan. And quite frankly, the other alternative is to have a will. Because in a sense, the revocable living trust, which is really simple, becomes your will. It has all the loving instructions in it, and the will becomes antiquated. You don't need it if the trust is properly funded. But before I go there, let's talk about the 4 major reasons that you should have a revocable living trust. One, and the big one that many people hang their hats on, is that it avoids probate. And there's 5 reasons to avoid probate. It avoids the cost of probate, it avoids the time delays, and the cost can be anywhere from 3 to 13%, depending upon what state you're in. Attorney's fees and other issues, the cost can be prohibitive. The time, it can take a year, it can take, well, I've had one client, it was years that his father's estate was open. Publicity. I mean, some salesmen make their living off of reading wills. In some states, probate is public. In many states, probate's public, so people can find out where the money's going, where it's passing. And complex. In some states, well, if you have more than one property in more than one state, you'll have something called ancillary probate. Talk about cost and time delays. And then there's contests. Oh, my kids love each other, someone will say. Well, when people die, people left behind often change. And you don't know what's going to happen. So, and when you have a revocable living trust, the contests, you can still have people suing each other, but it's harder. And the money's already passed into the hands of your heirs. Whereas with a probate, you can hold up the money being passed to your heirs. And so avoiding probate is a big one. But perhaps the second and better reason is that what happens if you become incapacitated, which is 6 times more likely to happen to your clients in the next year than for them to die in the next year. So that being the case, if you don't have something called, with your will, a durable power of attorney, which many people do, then your spouse will have to go to the courts or whoever and get permission to spend the money and to take care of you, and it's going to cost money going to court. And you can avoid all that court intervention by having a revocable living trust, which says, if I'm incapacitated, I want my spouse or my family to take over and take care of me and continue to make gifts or whatever you want done. Maybe put me first, the kids second, maybe put everybody equal. You can say what you want in a revocable living trust. And then the third reason for having a revocable living trust rather than a will are tax reasons. Now, you could do this with a will, but it's better done with a trust, and that is you can create, it's kind of an old school, but it's still good for a tactic that's wonderful today, is you create something called a B trust or bypass trust or credit shelter equivalence trust. You see, it used to be that you could pass on, or you still could do it, you could pass on everything to your spouse and you get the unlimited marital deduction. Mm-hmm. So there's no tax at the first death. Then your spouse dies and he or she gets their exemption. Well, what happened to your exemption? Well, you wasted it relying on the unlimited marital deduction. So many formulas, when we devise these revocable living trusts, call for the creation at your death of a bypass trust, which means we'll take your credit shelter equivalent or your exemption, in this case, I'm going to round it, at $5 million, and we'll put it into that trust. And now your spouse can be the trustee of it. He or she can be able to get to those assets if needed. But when she dies or he dies, then they have their own exemption, and your exemption's preserved because it went into the B trust and then it passes on to family owners.
Now, Mike, are you saying that a lot of people really do waste the first spouse, their credit then? I mean, they're not really setting this up in a bypass trust?
Right, but understand, there is a new, fortunately the law changed so that in 2012, so now we have something called portability. So if you don't do the B trust, portability works if certain things are done, and hopefully the attorneys will help make sure they're done. But so now you can pass, without the B trust, you can pass, it's new, to your spouse your exemption. However, it's better to have the B trust for a lot of reasons. One is the B trust, what if the assets in there double or triple during your spouse's lifetime? Well, they won't go into your spouse's estate to be taxed. They're outside the spouse's estate. Another thing is your generation skipping transfer tax isn't portable. What's that? Well, if the intention is to have these assets passed to your children, but at their death go on to the grandchildren, you're actually skipping Uncle Sam at the death of your children because they won't be able to tax it in their estates. And that's called generation skipping. Well, you have an exemption to avoid that problem, and instead of being taxed, the IRS will allow this. I mean, you're basically skipping over Uncle Sam at the children's death.
We come back from the break. We're going to go ahead and walk through some of the more interesting ideas as we're giving you an update for 2015 on estate planning with Mike Kilborn. We'll be right back. It's not how much money you make for your clients, it's how much money they get to keep, especially in retirement. But retirement income could cause Social Security benefits to be taxed. One tax advantage alternative is life insurance designed as a non-modified endowment contract that can generate tax-free income without taxing Social Security benefits. These contracts offer differing funding options depending upon your client's risk tolerance. For more information on how life insurance can be part of your retirement planning, just email me at steve@downtobusiness.tv. Brought to you by Ash Brokerage, the practice enhancement company. Well, welcome back to our second segment. Of course, we're with Mike Kilborn, top producer and CLU-CHFC. And Mike's a huge author. This book has been out and updated several times in publications.
It's 1999.
I love the line, "Disinherit the IRS." I mean, I couldn't find something more rewarding on my show than this title. So this is available, Amazon.com. You go out to your website.
Disinherittheirs.com.
Yeah, it's all there. You can go on it. And if you're saying, Steve, I really need to know everything that's going on, Mike has put this down, and think about this, it's actually in English and readable. It's not it looks like an anthology, but don't panic. It's got a lot of great material in there, and so I just encourage you to read it, and especially if you're wanting to do some of the things that Mike's going to be talking about all this week, a lot of that's in this book.
Yes, thank you. And there is a glossary in the back that has all kinds of terms defined, and a lot of people get lost in some of these terms, and you can find them in the back of the book. And I remember spending a lot of time to make sure that was pretty comprehensive.
Well, let's talk about another one. You talk about protecting heirs in the book.
Yes, in fact, quite frankly, that's the fourth reason. We were in a previous show and we talked about the reasons that she should have a revocable living trust, and of the four reasons, the fourth reason, probably the most, in my way of thinking, is the most important. Now, you could do it with a will, but it's better done with a trust, and that is, well, first let me make a statement. Nobody should leave anything of any consequence to anybody outright. Now, they should leave it in trust. You say, well, Mike, no, I just want my kids to have the assets. I don't want to. Look, why not help and protect your children? Let me explain that. If you have, let's say you have 3 kids, and you have 3 separate trusts. Well, it depends on the state, but you can make them the trustee of their individual trust. And or you might want to make them a co-trustee, but let them pick the co-trustee, be able to fire them and hire another. But the bottom line is, the reason to have it is, well, first they'll be able to have the income from their trust and the principal if they need it for health, education, maintenance, and support, which is pretty much everything. Technically, they're not supposed to be able to go to Las Vegas and put the trust money on the dice table, but they could even get away with that. So people say, well, why bother with the trust? And here's the answer. Whatever's in trust is free from the claims of creditors, free from predators, and free from divorce. And if we do it right, when they die, if they haven't spent it all, it'll go on to the next generation without another layer of tax in their estates, in case their estate's large enough to attract tax. I mean, this is a wonderful thing, and you're protecting them. I mean, I can think of, okay, I had a friend actually, who in Texas, when things were really bad with real estate, and he lost everything. I mean, it was just awful. And he was a good person, but he had all these limited partnerships. And including up the $1 million his mother left him. Now, if she had left it in a trust, he might have lost everything, but he would not have lost that $1 million, and he would have had seed money to restart. And so you can protect your heirs. In fact, I say to my clients, if what I said was true and you don't hurt them, they're their own trustee. In fact, in Florida, they can be their own trustee, not a co-trustee, and they still get all those protections. It depends on the state. Then why wouldn't you do this? I mean, I say that to clients. And of course,
well, let's look at this, because I like to kind of get a pictorial view of what you're talking about here.
Sure. Well, so we start out at the top. We see that there's an $18 million estate given. Let's say the current estate's $10 million, and it grows over time, and then you die. So there's $18 million. Well, the first thing that happens is we're going to divide and take out the credit shelter trust when you die. That's the B trust, as I said, which could multiply many times. Okay. Then the balance will go to your spouse. We put it in a special trust for your spouse called a Q-TIP, Qualified Terminal Interest Property Trust. And it's for the spouse's benefit. And again, you're protecting your spouse this way. And lastly, we created ILIT, Insurance Trust, or Irrevocable Life Insurance Trust, ILIT. And there we had $200,000 insurance, but we bought another $3 million worth because we know someday we're going to face some serious tax. So now your spouse dies, and after tax, well, the IRS is going to get their $3.2 million from your spouse's $13 million estate. We're giving your spouse their $5 million exemption. We're rounding here. And then the after-tax estate, $9.8 million, add the credit shelter transfer from the bypass trust. It could be more, but let's say $5 million. And you've got your insurance, $3.2 million. You got Uncle Sam paid. And so the heirs end up with $18 million. And so this is a simple plan, and it works.
Yeah, I like it. It's really a great outline. Now, in this here, what are you doing here? I noticed you split this up a little bit.
The third point, we were making a point about maybe having the spouse not leave things directly, because if you leave things directly and rely on the unlimited marital deduction, there's no estate tax at the first death, but at the second death you only get one exemption, and then Uncle Sam gets a tax. Well, actually, there's something called portability, and you can get around that using it, but this is a better way to go for lots of reasons that we discussed earlier. And so the better way to go is to have a credit shelter trust, the marital deduction, which is basically the balance, and spouse two dies, and at the end the IRS gets zero, and the son gets the full $10 million. Again, relying on both of their exemptions. So we preserve both of their exemptions to.
Now, before we close out the show, do you see this a lot where people are making this mistake? They're not really splitting it up. They're not using the bypass trust?
Not as much anymore, because they've got this. First of all, many people's plans included the old A-B arrangement, A trust, B trust being the bypass trust. And now if they don't have that, they've got the portability arrangement. But again, using the B trust is better because of all the growth that could occur into this credit shelter trust. This might double or triple. This might be a lot more because this grows, because the spouse doesn't need to have the income during his or her lifetime.
Mike, if somebody have already done their estate planning, but so many things have changed, how far back would I go? 3 years, 5 years to go ahead and look at this again?
Oh my God, I think everybody should review their estate plan every 2 to 3 years.
So no less than 3 years. Yeah. This could be a great opportunity for you to get in front of your clients. Huge idea, great book, and I hope that you appreciate what we're doing today. We're taking a top producer, a person that makes serious money as a top of the table performer, and giving us some of the insights of how he uses it in his practice. Well, that's all the time we have for today. Remember, before moving forward with any of the ideas on our show, always consult your tax advisor, legal counsel, or your broker-dealer compliance officer. Missed an episode? Just go out to our video archives. And remember, you could be wiser as an educated advisor. I'm Steve Savant. See you.